Hey guys, welcome back for another video. So in this video, I'm going to be talking about the hearsay exceptions. So hearsay is something that you typically hear comes up in custody cases. And basically hearsay is, in plain English, is a statement that was made out of court that is now being offered in court to prove the truth of the matter asserted. Basically what that means is that there was a statement that was made outside of court that now either you or someone else is attempting to use in court to prove that whatever that statement that was said is true. And so the reason why it's typically not allowed unless there is an exception that applies is because of credibility issues, right? If we don't have the person here in court on the witness stand to cross-examine, how do we know for sure that this statement is accurate? So that's pretty much the rationale behind that, okay? So what I want to do in this video, this was a requested video. I had one of the somebody, I don't know if it was this person's subscriber or not, but basically left a comment asking if I can make a video talking about the hearsay exception. So here you go. Now, because there are a lot, I'm going to focus on the ones that I've seen in my practice typically come up in like a family law case. I'm not going to go over every one in this video. And I'm also going to focus on the Maryland rules of evidence, okay? So I'm going to be focusing on the Maryland rules of evidence. That's where I'm licensed. So I'm going to be focusing on those rules. I would recommend that you look at the rules that are applicable in your jurisdiction, okay? So with that being said, we're going to get started. Okay, so the first exception that I want to highlight is, now this would be Maryland Rule 5-802.1, and if you're not in Maryland, that's not really relevant to you. But the hearsay exception is prior statements by witnesses. And what I'm not going to do is just give you all legalese. I'm just going to go over these the best way I can using like plain English. And so basically an example of a prior statement by a witness, this would be a statement that is inconsistent. So this would be where a person made a statement, right, previously, and now they're testifying in trial. And the exception would be the hearsay exception. The hearsay exception would be prior statements by witness. So this typically happens a lot of times in family law cases where maybe you had a pendente lite hearing, right? That's a prior hearing, right? And there may be a transcript of that hearing, which I would actually encourage. You should definitely look into getting a transcript of the prior hearing, especially when you're going through a custody battle against a narcissist, right? So maybe that person made a statement in the pendente lite hearing that was different, that was inconsistent of the statement that they're now trying to offer in court in this present hearing, right? So maybe this is the final merits hearing. That would be an example of a prior statement. Another example of a prior statement would be in an answer to interrogatory. So during the discovery period, there are a request for interrogatories, request for production of documents, maybe request for answers to admission. And so in the request to answers to interrogatories, there's a paragraph that basically says that you agreed to answer these questions truthfully and accurately to the best of your knowledge, right? So there's like a perjury clause in the request for interrogatory. So now if there's a statement that you made that is different in your answers to interrogatory from what you're testifying to today, that can be an example of a prior statement, okay? So that's all I'm going to cover as it pertains to a prior statement for the purposes of what you are likely to experience in a custody case against a narcissist, okay? So we're going to go to the next exception, which I'm going to go over. And these hearsay exceptions that I'm going to go over now, the unavailability of the declarant is not required. So that basically means that in order for you to use one of these exceptions, it does not matter whether the person is available now or they're no longer available for many different reasons, okay? So let me try to think if there's another way I can explain that. So let's say, for example, there's a hearsay statement, you have an exception for it, and you can use that exception regardless of the fact if your witness is present in court or not, right? Because their unavailability is not required. Hopefully that makes sense, okay? Hopefully that makes sense. So the first one I'm going to go over is a very, very popular one in family court, which is statement by a party of opponent. So basically that hearsay exception says that any statement that the other party makes, it's hearsay technically, but it falls under the exception of statement by a party opponent. So where would you most likely see this? You will most likely see this in the text messages between you and that person, the emails exchange, the email exchanges between you and that person. Those are all statements that they made outside of court that you're now trying to offer in court to prove that they said those statements, right? So technically it's hearsay, but it falls under the exception of statement by a party opponent. That's probably one of the most popular hearsay exceptions that you're going to see in family court. There are other there are other ways where it could be a statement by a party opponent, but for the purposes of this video, I'm not going to go into depth in this video. But if you're interested in me covering more of the other ways that this exception could be met, let me know by hitting the like button, and I can go into this a little bit more in depth. But for now, just think about, okay, you're in court, you're going through a custody battle against the other parent, right? And those statements that other parent made to you outside of court via text message and emails, those are hearsay statements that meet that exception. Okay. All right. Moving along. The next exception we're going to talk about is present sense impression. So I remember learning about this in law school in the context of like a lot of criminal cases, right? So criminal cases. So a present sense impression would be, say, for example, if you walking home and you hear some screaming on your route to your house, and you look over and you see somebody robbing an older lady at like gunpoint, and you have a clear vision of this person's attire, what they have on, you can hear what they're saying, and you call in 911. You're like, oh my goodness, I'm walking home right now and I see this guy. He has on a gray hoodie. He's telling this lady, give me all your money, or I'm going to end it, and I'm very concerned. Please get the police here immediately. He's, 6'2". He's, about, looks like he's about 210 pounds. I can see he has a scar on his left cheek. I can tell that he has a tattoo on his forehead, whatever. I don't know, right? That's a present sense impression because you're describing what you see while you're perceiving the event. Okay. So that would be an example of a present sense impression. Another example of a present sense impression would be, let's say if you don't call the police right then and there because you're scared, because you don't want the robber to hear you talking to the police. So you say, okay, I'm not going to call right now, but when I get in the house, I'm going to call. So you don't call 911 right at that moment, but you wait, maybe about 5 minutes until you get into the house. And then you call and give a recollection of what you just saw. That would be considered as a present sense impression. Okay. I haven't really used that one much in custody cases, honestly. I'll be honest with you. Yeah, I haven't really used that one much, but that, I just still wanted to go over that one. The next one is excited utterance. So excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. So again, I remember learning about this one in the context of a criminal case. So same situation. Let's say you're walking home and you witness this robbery going on, and then you make a loud noise because you're like, oh my goodness, he has a gun, and then a robber looking at you like, oh my gosh, they can see what I'm doing. Let me come after them. I don't know. This is an example that's coming to my mind in a moment, so don't judge me. And so you see him coming, so you running and you call the police and you shrieking and like, oh my gosh, he's gonna get me, that would be an example of an excited utterance. I can't really think of an example right now in the context of family law, maybe except for like a domestic situation, right? Like that was like a domestic, because a lot of times criminal law and family law kind of overlaps. So let's say, for example, that was a domestic situation and maybe somebody's coming after you, trying to attack you, maybe your significant other, and you're calling 911 and you're like, oh my gosh, he's about to hit me. That would be an example of an excited utterance. Okay. The next exception that I'm going to go over is then existing mental, emotional, or physical condition. This one doesn't come up much not in my experience, but basically this one is a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition offered to prove the declarant's then existing condition or the declarant's future action, but not including a statement of memory or belief to prove the fact remembered or believed, unless it relates to the execution, revocation, identification, or terms of the declarant's will. I'm not going to go over that one because it's very rare that you're going to even use that. I'm going to be honest with you. So we're not even going to go over that anymore. However, I will go over this next one, which is statements for purposes of medical diagnosis or treatment. So This exception says refers to statements made for the purposes of medical treatment or medical diagnosis and contemplation of treatment and describing medical history or past or present symptoms, pain, or sensation, or the inception of general character of the cause or external sources thereof, insofar as reasonably pertinent to treatment or diagnosis and the contemplation of treatment. Okay, that was a lot. So basically, and that could be overwhelming. But I'm going to summarize that by saying you could potentially use this in a sense where, let's say, for example, I'm going to go back to like let's say, okay, this is a divorce case, right? And you are at your doctor, and let's say, one of the things you want to highlight is the reason for your divorce was because of how this person was treating you. They caused you a lot of emotional turmoil, that so much so that it was affecting your health. And so you had to go to the doctor. And so you go to the doctor and they say, well, how can I help you? What brings you in today? And they're like, oh my goodness, my spouse has been so evil towards me. He or she, or, whichever pronoun you use, was just has been so just vindictive and just belittles me, puts me down, hides my medication, because I have these certain illnesses, and it's just been doing all these things to me, and it's been causing me so much stress, and it's just going down that whole rabbit hole there, the explanation, rather. And so that would be a statement for the purposes of medical diagnosis or treatment. Now, question: does the other party's attorney or the other party, their pro se, want that statement coming in? No, they're going to say, oh, objection, this is hearsay. And so it'll be on you to say, Your Honor, this meets the hearsay exception for statements for purposes of medical diagnosis or treatment. Okay, so that would be an example of that exception. I'm going to go over one more for the sake of time. I don't know how long I've been talking, but I feel like it's been a long time. So the last one I'll go over is records of regularly conducted business activity. Basically, the business records exception. So you're going to use this one a lot. I'm trying to think of, okay. So for example, I recently used this exception. Well, actually, I'm trying to think. I don't think I needed to use this exception for this one particular case that I was thinking about. But just think about it in a sense of, like, let's say, for example, you have bank records. Okay, you have bank records that you want to introduce, and maybe you want to introduce those bank records to show the income of the other party, because maybe they are self-employed and they don't have pay stubs, and so you want to introduce the bank statements. Well, you have to be able to meet the hearsay exception because those records are hearsay, right? You may also have an authentication issue, but we're not going to focus on that. We're going to focus on hearsay for purposes of this video. So the records of regularly conducted business activity, basically, I'm going to try to just summarize this in like plain language. You have to show that the documents were made at or near the time of the act, event, or condition, that it was made by a person with knowledge or from information transmitted by a person with knowledge. It was made and kept. Now, this part is key. It was made and kept in the course of a regularly conducted business activity. I'm going to pause there. So, creating bank statements is where am I here? Is a regularly conducted business activity. Okay, it's key. You can't just say it's a business record when that's not even a part of their business. Like, it's not a part of their business to regularly conduct to regularly make these reports, right? If it's like a one-time thing or something like that, you can't say that this is a business record, because that's not, they don't do that regularly. You get the point, okay? Indeed, the regular practice of that business was to make and keep the memorandum, report, record, or data compilation. Okay, so how can I summarize this in a way that makes sense to you? Basically, think about it this way: the business record exception is going to be for those things like bank statements. Okay, I'm trying to think, school records. Okay, like, say for example, you want to admit like school records of the child's like enrollment history or something like that. So in the context of like family court, how would this, like, what would this would be an example of this? Would be like bank statements, school records, maybe cell phone records. Those are the three that come into mind right now. Okay, so with that being said, I'm going to there are a lot more. Okay, so I would definitely encourage you to consult an attorney in your jurisdiction. to at least go over the rules of evidence with you. Okay, there are pro bono services. If you cannot afford to do a consultation with an attorney, I would encourage you to contact your local bar association and find out what are some pro bono services. I know in the state of Maryland we have like family law hotlines, so you can at least call and you can ask them questions like this, right? Like, can you explain to me what the hearsay exceptions are? And they'll be able to tell you. And so that's just another resource as well. So this was helpful. Let me know by hitting the like button. Also, please comment down below and let me know some suggestions of future videos that I can do that'll be helpful for you as you navigate this journey of represent yourself against a narcissist. And I want you to remember that you're not in this journey alone. Okay. I know it can feel scary. I know it can feel overwhelming. I know there's so many mixed emotions that comes with representing yourself in court against a narcissist. People have horror stories. People have they know people that have had horror stories, but I don't want you to operate out of a place of fear. Okay. So, that being said, remember you're not in this journey alone. Let me hold your hand and walk with you. And until next time, be blessed, stay blessed on purpose. Take care. Bye bye.